Well, good morning, good morning, good morning. This is the Minister M.L. Kimble coming to you live today. Let me make sure that we do have a good microphone. I am coming to you live today so that we can cover the HCV case that is obviously in the court today. We have now filed our amended complaint with the actual details of what transpired with State Farm Fire and Casualty Company and our corporation, the HCV Distribution Corporation, which is a minority-owned corporation that was established back in 2019 with a group of myself and a couple other people. We got together, we designed a corporation, and we set up a couple different businesses that were birthed out of that corporation. One of those businesses was the HCV store, the former HCV store that was located at 106-108 South Main Street, Swanton, Ohio. Now, those of you that have been following this situation, you know this situation from the beginning to the end. You know what happened. You know what we have been faced with and what we have had to face throughout this entire time, seeking justice for what transpired in Swanton, Ohio. So I want you guys to please like, share, comment. Don't forget to subscribe to the YouTube channel at Word on the Street Talk TV. Again, and I am your host, the Minister M.L. Kimble, and we are going to go ahead and cover the lawsuit today. So obviously this is filed in the Court of Common Pleas, Fulton County, Ohio, case number 25C, V as in Victor, 00001. You guys can look this up yourself on the Fulton County website, Common Pleas website, which obviously this is where the complaint has been filed. You guys see that it's been stamped. So this is the case, and we are covering this with you today. HCV Distribution Corporation Incorporated versus State Farm Fire and Casualty Company and Jeff Lambert, which is located at 114 East Airport Highway, and he was the former agent of our policy. Complaint and jury trial demands. So obviously, again, we are requesting a jury trial in this situation because we have not been treated fairly throughout Fulton County. I mean, this case has been going on since 2022. We even have evidence of conversations between myself and the mayor, the current mayor of Swanton, Ohio, Neil Tope, direct conversations of describing the mistreatment and what we experienced with the Swanton Police Department. This went on without any type of anybody addressing it. There was no type of investigation of it, and it was just disregarded and overlooked. So we are going to file action against the Swanton Police Department as well. But we are dealing with this situation with State Farm and obviously the separate situation with McNeil Chevrolet. In my opinion, they're all involved. I don't know who to trust in that entire community, because at the end of the day, we were successful business owners, and the morning that our business was broken into, we became suspects. We were treated just like criminals. We were never treated like the victim from the beginning when we made our first complaint. And this complaint highlights in details what we actually experienced, even though it's still a little softer than what I, would expect, because I was the one that experienced it. It does cover what truly went down when we lost our business back in 2022. So I'm appreciative of that, because now the courts get to actually see what has been hidden over the last few years here. I mean, every complaint that we have filed in this court, based upon our previous legal representation, we were told not to mention all of the things that truly happened. Don't mention the racial discrimination and all of the things that we experienced, but that is something that should have been mentioned a long time ago. You cannot let these companies get away with discriminatory practices just because they feel like they can. Not at all. No, sir. There's a lot of things that happened throughout this entire time, and we're seeking the court's judgment because these guys are not going to get away with it. Simple as that. So obviously a complaint and jury trial demand. Parties and jurisdiction: Plaintiff HCV Distribution Corporation, Inc., HCV, is a corporation duly organized and existing under the laws of the state of Ohio. So let's stop right there. This is not some backyard business that was created with one guy. This is the way that State Farm has made this look the entire time, as if this was just a guy that opened up a business and had some insurance. That's not the case here. This is a duly organized corporation that has been existing under the laws of the state of Ohio since 2019. Now, its principal place of business is now located at 2034 Austin Bluffs Court, because that is the current mailing address, because our mailing address has no longer in Swanton, Ohio. It's due to what we have been fighting for. We've lost our entire business and location due to what this mistreatment by State Farm and all of these other people. Plaintiff is engaged in the wholesale and retail distribution of cannabis oil, CBD products, and maintains business operations throughout the state of Ohio. That is 1,000% correct. You guys can go back years upon years, even years when I was in Denver, Colorado, on the fields, in the farms, on the scene when CBD became as big as it is today. This is something that did not just start in 2022 or 2021 when we had 3 different retail locations. We started this corporation again back in 2019. Defendant State Farm Fire and Casualty Company, defendant or State Farm, is a corporation organized and existing under the laws of the state of Illinois, with its principal place of business located at 1 State Farm Plaza, Bloomington, Illinois, 61710. At all times relevant to this matter, defendant was and is authorized to conduct insurance business in the state of Ohio and has issued and administered policies of insurance to individuals and entities located within Fulton County, including plaintiff. Excuse me. Get some water here. Defendant's agent, Jeff Lambert, or defendant Lambert, is also a party and co-defendant in this matter. And he is an agent who operates under the laws of Ohio, and he has a principal place of business where he represents State Farm and seemingly his own business at 114 East Airport Highway, P.O. Box 65, Swanton, Ohio 43558. Understand, guys, Mr. Lambert was the agent that supposedly was representing our corporation through State Farm. He's the guy that signed our company up with the policy, but yet the same guy who ignored our calls the day that our business was broken into. In fact, his office ignored us 4 different times before we took the initiative to make the claim with the State Farm corporate office. So explain to me, like I'm a 2-year-old, why our business is broken into 6 miles from our agent, and we tried to notify him and he does not respond. I don't understand it. You have to explain that to me. But we had to file our claim with State Farm's corporate office because our agent chose not to respond to us the day our business was broken into. His name is Jeff Lambert, and he's located right there in Swanton. The acts, omissions, and misconduct alleged herein occurred in substantial part within Fulton County, Ohio, and concern an insurance policy insuring real and personal property located within the state of Ohio. Subject matter jurisdiction is proper in this court pursuant to RC 2305, and venue is proper in the Court of Common Pleas of Fulton County, Ohio, pursuant to CIVR 3B13 and 6. As plaintiff resides in this county, the insured property is located in this county, and the acts and omissions giving rise to this complaint occurred in whole or in part in this county. General factual allegations common to all counts. At all times relevant, plaintiff maintained a commercial insurance policy issued by defendant. So let's stop right there. Again, this was never a Marquise Kimble insurance policy. This was an insurance policy that was named and set up through the corporation for HCV Distribution Corporation. That's why it's highlighted as a commercial insurance policy. Issued by defendant, which provided coverage for property damage, theft, and vandalism for plaintiff's business premises located at 106-108 Main Street, Swanton, Ohio. That should be South Main Street. On or about January 17, 2022, plaintiff's business premises were subjected to unlawful entry, vandalism, and theft. That's when we walked in and the word nigger was spray painted all over our walls. Property was removed. The place was a complete disaster. This first incident caused substantial damage to physical property and resulted in the theft of inventory and equipment, along with the defacement of the business by means of racial slurs. The business was subjected to unlawful entry, vandalism, and theft again. So again, guys, this happened twice. Not only were we burglarized the first time, we have time-stamped evidence of the property, the premises, and what was left on the property while we were facing this unlawful, baseless investigation conducted by State Farm. This happened, although it was reported to State Farm, they refused to allow us to file a second claim based upon this case being investigated. So then they come back later and said, oh, you never filed a claim. It's because you guys refused to allow us to file a second claim because we were under investigation that you guys conducted 6 days after the break-in. The business was subject to unlawful entry, vandalism, and theft again. Make sure you guys see that again. Plaintiff, through an authorized agent. Again, this is not Marquise Kimble. The plaintiff is HCV Distribution Corporation, and I am an agent of the corporation. Marquise Kimble and others promptly reported the incident to law enforcement. No, we didn't report anything. Our alarm systems told Swanton Police Department that there was a disturbance going on at our business at 6:32 a.m. Now, they were located 0.2 miles from our business, less than walking distance, if you know what I mean. But somehow they did not respond until after 7:15 a.m. that morning. So we didn't call the Swanton police. I live 20 minutes from the business. We didn't call them and say, hey, there's a disturbance. Our store alarms notified Swanton Police Department, and they chose not to respond until over past 7:15 to our business, even though they were notified at 6:32. That's the facts. In accordance with the terms of the insurance policy, despite the Swanton Police Department being near the scene, 0.2 miles near the scene, its response was delayed by over an hour. All of this information was told to the mayor. I complained to the mayor about it. We've got documented conversations about what they did to me instead of treating me as the victim. When I showed up at the business, they immediately began to interrogate me, taking my fingerprints, separating me and my sister, and trying to get us to admit that, one, we had something to do with this, as if we somehow had previous knowledge that the police were not going to show up until 7:15. Upon arrival, officers interrogated plaintiff's principal officer. Again, it highlights that I am not the insured party. I am the principal officer of HCV Distribution Corporation. I'm pointing this out for a reason, because you guys have to understand the legitimacy of this complaint and what State Farm did. Mr. Kimble and his sister Jacqueline Kimble, in a coercive and accusatory manner, separating them without justification and without prior notice. Following plaintiff's submission of its insurance claim, defendant initiated an investigation. Let's talk about that. They literally started an investigation 6 days after our business was destroyed. So instead of being the good neighbor as they claim and trying to help us get our business started back up, these guys immediately put everything on hold and initiated a baseless investigation 6 days after our business was destroyed. Rather than conducting a thorough and impartial inquiry, defendant delayed the claim process for over 250 days. Actually, that should be over 319 days, issuing repetitive and burdensome requests for documentation, the same documentation, while withholding meaningful updates or progress, all against the Ohio Revised Code. Whenever the insurance company is initiating some type of investigation, they are required, according to the Ohio Revised Code, to update you and give you reasons of why they are continuing this investigation. They have to give you an update every time they are deciding to extend. State Farm never once updated us. In fact, we've got numerous emails asking them for an update of our insurance case. They kept prolonging and prolonging and prolonging. And then when we refused a $15,000 out-of-court settlement that they offered us, then they came back with a denial without any legitimate just reason to do so. During this delay, defendant's agent, Special Agent Lonnie Johnson, among others, made false and defamatory statements concerning Mr. Kimble, including unfounded accusations that he had orchestrated the vandalism of his own business. How could I or anybody orchestrate a vandalism when the police were notified at 6:32 and didn't show up till 7:15? Wouldn't that mean that we would have to have some type of knowledge about when the police were going to show up? It's all a bunch of horse shit. And these guys need to pay for what they did. We're not giving up until they do. Defendant failed to pursue credible leads involving third parties, including individuals affiliated with the neighboring business McNeil Chevrolet. Why is this important? Not only is there a legal complaint in Lucas County with a civil rights complaint against McNeil's between myself and McNeil Chevrolet, but this is my former employer for the last 7 years. If you're conducting an investigation, why didn't you contact anybody at my former employer that I worked as the finance manager for 7 years until I chose to resign? You want to explain that to me like I'm a 2-year-old? You cannot say to me you've conducted a full investigation, but yet you do not contact anybody at my former employer, yet you're focusing your whole investigation on Mr. Kimble. Defendant's claim was denied, and the denial was predicated on purported discrepancies in plaintiff's inventory and speculation regarding Mr. Kimble's personal finances. Again, why is Mr. Kimble's personal finances even a point of subject here when I am not the insured party? The insured party is the corporation, but State Farm focused their determination on my personal finances and used that as personal part of the reason that they came up with a baseless denial. All violations of the Ohio Revised Code, which requires that the insurer conduct a full, thorough investigation. And if you did these things, then you should not have been facing anything on my personal finances without looking at the rest of the officers of the corporation. We've got other corporate officers in the HCV Distribution Corporation. Why was Mr. Kimble's personal finances singled out and no questions asked to any of the other corporate officers? None of which were substantiated. Instead, defendant's conduct reflected an intent to discredit plaintiff and its principal officer, again, Mr. Kimble, based on discriminatory motives. Defendant's misconduct further included the unauthorized disclosure of confidential policy information to third parties. This is important, guys, because this is a blatant violation of the Ohio Revised Code, which prohibits insurance companies from disclosing any information to anybody that is not listed on the policy. I don't care what their title is. I don't give a shit if they're the garbage boy in the back. If they're not listed on the policy, according to the Ohio Revised Code, they are not supposed to have information given to them from the insurance company. So it says that she testified in a recorded deposition that she had knowledge of and involvement in matters concerning plaintiff's policy. Let me go ahead and go a little deeper here. She not only said she had matters knowledge of, she flat out said that she contacted State Farm's corporate office and was told that our claim had been denied. A complete violation of the Ohio Revised Code, because she is not listed on the policy. She is not the landlord. This was a recorded land contract, which makes her nothing less than the lien holder of the property. So in other words, State Farm disclosed to this woman, who was the lien holder of our property, not a landlord, information about our policy that she should not have had, which gave her privy knowledge to lock the doors on us illegally and unlawfully dispose of our property, all while under insurance investigation with State Farm. This was reported to them, and they did nothing about it. Ms. McSorley subsequently changed the locks on the insured premises and participated in unauthorized property auctions. To this day, we have not received any of our property that was on that premises. We had furniture, we had camera systems, we had security, we had personal property. It was personal information with customers' information in there. I'm a tax preparer, so there's previous tax returns for people. All kinds of things that was in our office that was not returned and unauthorizedly disposed of by this lady that was given information she should not have received, unauthorized, by State Farm. Video and photographic evidence, including time-stamped surveillance footage, confirms that a second burglary occurred at the insured premises under defendant's watch and while the claim remained unresolved. As I told you before, local law enforcement, again, State Farm, failed to, SWAT and Police Department, failed again to investigate this incident, and defendant took no steps to protect plaintiff's interest in the property. Defendant's acts and omissions included but not limited to the publication of false statements, failure to conduct a proper investigation, racial animus, unreasonable claim delay, and breaches of contractual and legal duties have caused plaintiff to suffer significant financial loss, emotional distress, and irreparable harm to its professional and personal reputation. Count 1, breach of contract. Plaintiff incorporates by reference all allegations contained in this document as if it fully set forth herein. Defendant entered into a valid and enforceable insurance contract with plaintiff, which provided coverage for property damage, theft, and vandalism. Plaintiff fulfilled all conditions present to recovery under the insurance policy, including timely reporting the incident and cooperating with the defendant's investigation. That's important because not only did we cooperate, we gave them so much information that they lost record of the information we gave them. State Farm literally lost record of some of the documents that we provided to them, telling us that they could not keep up with our information. They hired a third-party accountant that said he couldn't understand our accounting system, but yet they used his determination as to why they denied their claim. 1,000% violations of the Ohio Revised Code, and I still don't understand how these guys have not been fined yet for what they did. Defendant breached the insurance contract by failing to conduct a thorough and impartial investigation. If they did, they should have contacted McNeil's. They should have contacted the people that we gave them as potential suspects, as in Mike Wells, our former landlord, that we had several racial discrimination complaints of his harassment that we turned into the Swanton Police Department, and nothing was done about it. He harassed our business every single day. He could have been potentially responsible. McNeil's told us that he could have been responsible. We gave that information to State Farm, and they never, ever once investigated him. And ultimately denying the claim without substantiated reasons in August of 2022. At that point, all of plaintiff's property had been stolen at that point as the landlord. She was not the landlord, so I don't know why that says landlord. There's something the attorneys revised, so we need to make sure that's corrected. Not the landlord, but the lien holder of the property, Deborah McSurley, not McFurley, removed all items from the property because she had unlawful privy to confidential information provided by defendant and its agent, Jeff Lambert. As a direct and proximate result of defendant's breach, plaintiff has suffered damages, including but not limited to financial loss, emotional distress, and damage to its reputation. Count 2, fraud. Plaintiff incorporates by reference all allegations contained in this document as if fully set forth herein. Defendant, through its agents, made false and defamatory statements concerning Mr. Kimble, including unfounded accusations that he had orchestrated the vandalism of his own business and that he was associated with criminal activity based on his appearance. State Farm published that I showed up wearing a blue suit with a loud tie, with excessive jewelry, and was very braggadocious. Now, you want to tell me what does that mean when you're determining an insurance claim? And what in the hell, God's green earth, did my appearance have to do with the corporate insurance claim that we filed? Not to mention, I'm a professional minister. I'm a notary. I know how to show up at court respectful. This is something that they published on purpose while they were determining our insurance claim. 1,000% racially discrimination. 1,000%. If you look at the Ohio Revised Code, you shouldn't even be documenting what my appearance looks like unless this was a case that involved an accident. Why are you talking about my clothes and my loud tie and your opinion, and you're documenting this information? This was done by State Farm's first attorney, Mike Manahan, and put in the documentation as the reasons why they denied our corporate insurance claim. Defendant's statements were made with the knowledge of their falsity or with reckless disregard for the truth, intending to discredit plaintiff and its principal officer. Plaintiff relied on defendant's representations to its detriment, resulting in significant financial loss and reputational harm. Count 3, racial discrimination. Plaintiff incorporates by reference all allegations contained in this document as if fully set forth herein. Defendant's conduct, including the publication of false statements and the denial of plaintiff's claim, was motivated by racial animus against plaintiff and its principal officer, Mr. Kimble, and others associated with plaintiff and Mr. Kimble. Plaintiff entered into a contract to purchase the property, wherein its business was maintained by land contract with Ms. McSurley, and defendant intentionally shared confidential information so that Ms. McSurley would terminate plaintiff's opportunity to purchase and hold the real property for its brick and mortar business location. Defendant intentionally acted to deny plaintiff due to Mr. Kimble and his appearance. We just talked about that. The business's due compensation under the policy. Defendant's discriminatory actions have caused plaintiff to suffer significant financial loss, emotional distress, and irreparable harm to its professional and personal reputation. Count 4, violations of the Ohio consumer protection laws. Plaintiff incorporates by reference all allegations contained in this document as if it fully set forth herein. Defendant engaged in unfair or deceptive acts or practices in connection with a consumer transaction in violation of Ohio Revised Code Section 1345. Plaintiff was a consumer, and the insurance policy and other representations made by defendant constitute a consumer transaction subject to the Ohio Consumer Protection Laws. Defendant, through its agent and defendant Jeff Lambert, represented that it would provide plaintiff with quality insurance and that it would be like a good neighbor and thoroughly investigate and treat plaintiff fairly and as consumers of quality insurance so that plaintiff would be induced to enter into contract with the defendant. Defendant's actions, including misrepresentations regarding the insurance policy and the authenticity, fairness, and quality of the faulty and discriminatory investigation, which led to the improper denial of plaintiff's claim, constitute deceptive practices under Ohio law. Defendant's conduct was unconscionable, and it knowingly took advantage of plaintiff's inability to protect his interests and made misleading statements on which plaintiff relied to its detriment after it made itself out to be a company who is like a good neighbor, implying that it would show defendant and its agent due respect and impartial treatment as consumers who pay premiums on time with a good faith intent. As a result of defendant's violations of the Ohio Consumer Sales Practice Act, plaintiff is entitled to damages included, but not limited to financial loss, emotional distress, and attorney's fees and punitive damages. Count 5, negligence. Plaintiff incorporates by reference all allegations contained in this document as if fully set forth herein. Defendant Lambert had a duty as plaintiff's insurance agent to not share confidential or false information about plaintiff or its employees and executives, which would harm plaintiff with outside individuals. State Farm corporate office did that based upon under oath evidence, as well as Jeff Lambert, the agent for State Farm. He said under oath that he was talking to not only Deborah McSorley, but Deborah McSorley's sister and her brother. None of these people were listed on our corporation's policy and had no authorization to be discussing anything concerning our corporation with our agent. Defendant Lambert further had a duty to properly inform plaintiff regarding the claim, which he never did, and the legitimacy of defendant's operation as an insurer, and how its business model was to take advantage of those who are subject to stereotypes that would diminish business legitimacy and hence leave those disadvantaged subject to denied claims without justification. Defendant Lambert shared false and confidential information with individuals, and that sharing of information harmed plaintiff and was the reason plaintiff lost its opportunity to own real property through a land contract and lost its property without due compensation under the insurance policy. As a result, plaintiff lost its real property and was not treated fairly during its claim process as insured and did not recoup funds that should have been due and owing plaintiff by defendant. Conclusion: wherefore, plaintiff prayed for a judgment against defendant to include compensatory damages, consequential damages, special damages, all economic or non-economic damages applicable, punitive and or exemplary damages, attorney's fees, court costs, interest, and any and all other relief found to be just and proper by this court or the record as it become apparent. Respectfully submitted. Both of my our corporation's attorneys. It's been respectively submitted. We're demanding a jury. Obviously, plaintiff hereby requests a jury demand for the jury to decide all issues triable to a jury. And a certified copy was sent to the parties. So as you guys can see here, this is the actual official complaint that has now been amended and filed in Fulton County Court. And at this point, we are seeking a jury and we're waiting for the court scheduling. If State Farm wants to take this thing to trial, we are ready to go back in before the court because they will be held accountable for the things that they did to cause destruction on our business. Thank you for your support. Please like, share, comment. Don't forget to subscribe. If you choose to donate to our platform, you can do so by using our hashtag at hashtag donate KNSMIN. I am the Minister M.L. Kimble, and it has been my pleasure to go over this with you today. Be blessed. Until next time.
love you. You must know that you are on my mind, on my mind. Not for this minute, but all the time, all the time. This song I write is just for you. I'm wondering if you know this love is true.